returnable by 3rd. Yes.
20.
ಆಮೇಲೆ ಮಾಡೋಣ. Yes.
For the petition number 2, respondent number 2 in this case, petition. That shall be settled between the parties.
Settlement 498 ಏನಾ?
Please.
ಹಾ. ಅವೇ. Yes.
Parties are present.
ಎಲ್ಲಿದೆ ಫ್ಲಾಂಕ್ ಇಲ್ಲಿ ಪೆಟಿಷನ್ ಇದೆ. ವೇರ್ ಇಸ್ ದಿ MC ಪೆಟಿಷನ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ?
150
ಪೇಜ್
MMT.
ಅದಲ್ಲ.
Only I have stated in my affidavit on page number 3.
You are not before the family court? ಅದು ಎಲ್ಲಿದೆ? ನಾನು ನೋಡಿದೆ ಇಲ್ಲ ಪೇಜ್ 56. ಎಸ್. ಪೇಜ್ 56 ಜಾಯಿಂಟ್ ಮೆಮೊ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್. ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ ಅದರಲ್ಲಿ.
In DV case we have filed a joint memo and
one petition. Yes. 2. Black Academy. Who is this respondent?
Respondent number 2.
BT Venkatesh yaru?
I'm for the petition.
You are BT Venkatesh. You are always reachable, huh? Reach law.
Yes, you are.
Your firm is Reach Law. Yes. All right.
I have to hand over file check DDO.
The learned counsel for the petitioner submits that the conditions stipulated in the settlement have all been fulfilled, and a demand draft of 5 lakhs is handed over to the counsel representing respondent number 2, which is acknowledged in acceptance. ಅಷ್ಟು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಕ್ಲೋಸ್. ಎಸ್. ಇವ್ರು ವಕಾಲತ್ ಹಾಕಿದಾರೆ, ಹಾಕ್ಬೇಕು ಈಗ.
Just to file the second.
Yes.
21.
For petitioner, my lords. Lords, FIR is registered under section 13 of PC Act, my lords.
Pass over. Other matters are there. Yes. ಅಷ್ಟರಲ್ಲಿ you serve on BV Patil and come. During the course of the day ಮಾಡಿ.
आया के खड़ा है आ गया घर बैठे, नो टेंशन, सीधा खाते में पेंशन, नॉन स्टॉप. फिर तो दौड़ेंगे ना अपने बूढ़े घुटने भी नॉन स्टॉप.
हरियाणा सरकार ने अब सामाजिक सुरक्षा पेंशन की राशि 1000 से बढ़ाकर रुपए 3000 कर दी है. अभी तो बढ़ता जा रहा है. मारा हरियाणा, नॉन स्टॉप हरियाणा.
Next.
32.
Petition.
164.
Yes, my lord. 164.
Yes, sir.
My learned from Mr. Jagadish has to.
He has to reply.
The two aspects of the issue, man. One is with respect to deferring the decision of learned session judge while the objection is being raised. That, my lord, and I have no permission to make, because I think that Supreme Court in that matter says that whenever objection has been raised, has to be decided.
Decided. Yes.
That I will not stress on that issue. No?
Because Apex Court is already so.
Yes, my lord. Yes. Second issue, my lord. In the second issue, the two issues. One, whether 164 statement can be marked. Second, the statement made in 164 could have been deposed by the witness in the court.
That's all the issue.
Yes.
164 cannot be marked is what some judgments are.
In fact, their own judgment, which the learned senior relied on various judgments, my lord, the same judgment speaks about marking up 164 statement. Of course, the issue, my lord, the two issues, whether it is my signature available on 164 statement. So it is, if I am not identifying my signature, who has to identify the question? Therefore, the very judgment, my lord, I'll place those, the sum of the judgment which they have relied on, their 164 statement has been marked. The second issue, my lord, whether the statement given under 164 could have been deposed before the court. Now the statement under 164, my lord, I'm not saying that it is a statement treated as an evidence. All the judgment which they relied on is on the context of whether a conviction can be be awarded based on 164 statement. Answer is no, because it is just one, probably it's as equal as 161, but it is just sanctity purpose. It has been as an extra issue. So here, my lord, that this 161 or 164, these are all earlier statement made by the witnesses. So now, both the prosecution and the witnesses, the 161 statements can be used, my lord, either for corroboration or contradiction.
Yes.
Now, I am corroborating based on what my witnesses spoken about in the past.
No, but that
treat the
marking
witness
of
first
it
time.
is marking of it goes because it is objection is upheld.
Correct. No, that
Allah, marking of it goes under there. The contents of it you're trying to narrate now. You're seeking elicitation of what is there in 164 when that
I could have deposed what is there in 164 statement. And my submission, my lord, this is equally a statement which is made under 161. It is an earlier statement which can be relied on. The issue, my lord, the senior has referred one judgment, my lord, Supreme Court judgment in 1972. Your lordship may take the same judgment, my lord, 1972.
1972.
Ramkishan Singh.
1972.
1972 volume 3.
Ramkishan Singh, my lord, para 8.
Ramkishan Singh, para 8.
ಈ compilation ಇದೆ
ಇಲ್ಲ separate ಆಗಿ ಕೊಡಿ.
Separate ಆಗಿ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಕೊಡಿ.
No, this judgment, well, may I read that para 8 once again? The statement under 164 Code of Criminal Procedure Code is not a substantive evidence. There is no quarrel with that,
Yes,
my lord.
absolutely.
It can be used to corroborate the statement of witnesses. Now, what we are doing is corroborating the witness's statement.
Treat her hostile and then do it.
No, the abstaining is only for marking of the document. We are not asking for marking of the. Once I mark the document, my lord, I need not. Just because documents have been marked doesn't mean that, my lord, the court will consider the entire document. It is ultimately my narration which has to be brought before the court, and I have narrated it. And it is this judgment doesn't prohibit, my lord, then corroborating the statement. In fact, this very judgment speaks that the statement should be can be used for corroboration, and I am using for corroboration. And your lordship may see para 10, my lord, the High Court, in setting aside the acquittal, this is again, my lord, your lordship, is in the question of where the conviction has been set aside. Acquittal has been set aside and conviction has been given solely based on 164 statement.
What is the last?
Therefore,
No,
my
that
lord,
cannot be. That cannot be. You can't convict or acquit or even quash proceedings under 482 relying on a 164 statement.
Yes, ma'am.
Yes.
Just one para, my lord, in the para 10, my lord. In setting aside the acquittal and that the result would have been different in the session judge had taken into consideration statement of so-and-so, exhibit P4, which the exhibit P4, my lord, is the 164 statement, which so-and-so had been confronted. So if there, my lord, that the witness have turned hostile, therefore that 164 statement have been used to confront them, and it is in mark.
There it is.
It
for
has been marked.
confrontation.
So this is my first submission, my lord, is with respect to objecting for marking itself, my lord, is a question. And this in the compilation, my lord, that I'll skip the first judgment, my lord, because
That's guidelines.
it's on the guidelines where it
Yes.
says that
All right.
in the guidelines only, my lord, your lordship may see at page para. Page 15, my lord.
Page
Page 13, my lord. Page 13.
13.
1-3.
Ah.
Just above para 11, my lord, one of the guidelines. This is continuation of the para 10 of the guidelines
Yes,
which is issued,
yes.
my lord, where they say reference to statement under 161 and 164 CRPC. Your lordship, you see the previous page, my lord.
Yes, sir.
During the course of during the cross examination,
Cross-examination.
the relevant portion of the statement recorded under 161 CRPC used for contradicting the respective witnesses shall be extracted. It is not possible. Now it is only what statement can be in 164, 161, my lord, only the relevant portion in which you are contradicting has to be extracted. It is not possible to extract the relevant part of the aforesaid. The proceeding officer is in discretion shall indicate specifically the opinion and closing words in such relevant portion while recording deposition through distinct marking. In such a case, I'll ignore that one, my lord. Your lordship may come to fourth one. In the aforesaid rule applicable recording the statement under 161 shall mutandis apply to the statement recorded 164 CRPC as well. Now, if 161, if I'm allowed to depose to the 161 statement, and I'm equally allowed to depose for 164 statement, this is what Supreme Court said it in the criminal trials matter.
Yes.
It's mutandis applicable. The one more, my lord, in their own compilation, my lord, the page 42. Page 42, my lord, para 23. This is the Somsundar judgment, my lord. This is again on 164 statement could have been marked or not marked. Your lordship may see para 23. And they're extracting these George versus Kerala in para 36, my lord.